This is a book about becoming a more creative lawyer, adopting a mindset that will help you solve seemingly intractable legal issues, prevail in cases that looked impossible to win, and help your client come out a winner even when you lose the case.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you not from Studio 3553 today. We're playing the home edition. Hopefully the dogs will cooperate. But helping us get set for sentencing today is a great guest, one I've been wanting to have on the podcast for many months, attorney Jon May. Jon is, I think once the moment I realized I needed to have you on the podcast, Jon, was I saw a presentation you did for NACDL, which is the National Association of Criminal Defense Lawyers. And it was basically called, I think, Trial Practice for the 21st Century. It was about trying your case at sentencing. And I'm like, wow, this guy gets sentencing in a way that many, or a lot, maybe most others do not, and we need to talk. And so that said, you just came out with a new book. You're a really prolific writer. You've written so many great articles over the years, and this book kind of encapsulates all that work. And again, amazing favorite. Is that a cat or a dog? Oh, it's a cat.
That's a cat. She's my associate.
Oh, good. I hope she's very qualified. She's probably way more quiet than my associates, because I have 3 of them running around here.
Well, you may hear from my other associates as well.
Okay.
So well, I've got the door shut, so you shouldn't, but you never know.
If they're half as learned as you, it will be in my utmost pleasure. But anyway, Jon just published a book with the NACDL Press, and it's called Who Says You Can't? Strategy and Tactics for Criminal Defense Lawyers in the 21st Century. I am so glad you're here. Welcome and Happy New Year.
The only thing is, Doug, they changed the title.
Oh, they did? What's the title now?
Well, the title now is Who Says You Can't? How to be a more creative criminal defense lawyer.
Okay, I like that better, actually.
I did too.
Well, first of all, I love Who Says You Can't, because, and this is really like one of the things that I love about you, because I want to be delicate about this, but you've been practicing for a while, right? And you know, how long? 78 you started your practice.
I've been practicing for 44 years, and I intend to practice for another 30. So you know, I'm sort of halfway, little more than halfway through my career.
And this is why I love you so much, because lawyers who are not only seasoned but successful, which you're both, kind of get stuck in this fixed mindset, which is, this is the way it's done. This is the way I've always done it. This is the way they do it. You can't do that. I'm not going to do that. And here it is, right in the title of your book, Who Says You Can't? And now you add this word about creative lawyering, which you know is that's kind of my jam. That's what I want. That's what I aspire to be in my professional life, and really my personal life, is just a creative human being. So let's dig in, man. This is I'm really excited. Love the new title. Let's do this first, because you know I love stories. And often when I have a great guest on the podcast, I want to hear their story. I want to hear their hero's journey, their origin story, if you will. And it could be in the law, but it doesn't have to be. I'm leaving it to you.
Well, as is very typical, I started out as pre-med in college, but as was true in law school as well, I was a terrible student, and I became editor of the school newspaper, the Emory Wheel, and I didn't spend much time on my studies. And I thought I'd end up being a journalist, because I wasn't doing that well in pre-med. And one day, my father came and visited me, and he said that he never saw me as a doctor, that there wasn't any future in journalism, and he always thought I should be a lawyer. And so I applied to law school. I was accepted at University of Florida, which was basically a business-oriented law school. So again, I didn't spend much time in classes, and except I did moot court, and I did also produce a booklet for low-income people, a handbook on consumer law that was ultimately distributed around the state of Florida. But I did things that I was always interested in and didn't pay much attention to other stuff. And I knew I was going to be a public defender. So it's like for federal civil procedure, I worked in the library, and one day the teacher, his name was Julian, who later became the dean of the law school, was talking to me, and I said I had his class next semester, and I said you'll see me for the first day and you'll see me for the exam, and his mouth just opened. So when I left University of Florida, I got a job as a public defender.
All right, can I stop you right there? Because when you said I knew I wanted to be a public defender, first of all, it's another soul connection, because I knew that in law school as well. I knew that. That's why I went to law school. But most of your colleagues, I'm guessing, like my colleagues, had zero interest in that, in pursuing that. And actually, it was, what firm can I work at? How do I pay my student? Like that, not a thing. I was an anomaly. I'm guessing you were too. But why did you know that? How did you know that? What about it?
Well, here's the thing. Despite the fact that I thought I wanted to be a doctor, growing up in my household, we didn't watch Perry Mason. I remember when I was little watching The Defenders with E.G. Marshall. You're probably too young for that show, but it was the first realistic lawyer show that dealt with very controversial issues. And my mother had a autograph signed copy of Louis Niser's My Life in Court. So I sort of grew up in a household that talked about law and legal issues and lawyers as celebrities. And then when I was in high school, I interned at the public defender's office and made some very good friends, learned a lot of stuff. So when I ended up going to law school, I knew that was what I was going to do. So my first job at a law school was with the state public defender for the 15th Judicial Circuit in Palm Beach County.
Nice. How did your dad feel? I want to know, who said, okay, medicine for you, not so much, but law. Did he have these visions of you being a different kind of lawyer, or was he down with the whole public defender thing?
No, he lived long enough to see me sworn in as a public defender, and he was very pleased.
Nice.
My father was always, sort of, he was always for the underdog. He was the kind of person that would help anybody. So, it fit into. I'm following in what I think he felt I should do. So,
well, I love that. I love that. It sounds like you had a great dad. I have a great dad too. He didn't quite understand my decision about the PD though, because he worked his life in corporate America,
Mhm.
and he knew financially what kind of life lay ahead for me, but also I think he was like so many people, like worried about how do you defend those people kind of thing. Like you're gonna be spending time with, what are you gonna be in the same room with people who killed people, like, and my nice Jewish mother was probably, beside
Yeah, well,
herself
my
too.
mom, my nice Jewish mother felt the same way. She did not agree with my father, but it was the whole thing was, how can you defend those people?
Well, and I'm so, while we're here, how can you? Because we get that's the most common question we get as criminal defense lawyers, and everybody's got their answers, and some of them are kind of standard pat responses, the Constitution, blah blah blah. But I'm always interested to know how great criminal defense lawyers respond to that question that we get at cocktail parties every New Year's.
Well, I started out as a public defender, and at that time, I was, committed to the idea that, the least fortunate of people in our society should have the same representation as the wealthiest. And, to the extent that we could give, and I happen to work for a terrific public defender's office, to the extent we could give our clients the best representation possible, that to me was important. When I left the public defender's office, but I left the public defender's office to spend 4 years at the U.S. Attorney's Office. But when I got back into representing defendants and representing defendants who were paying me, it really the impetus for my work, my motivation, really had to do with my concern for civil liberty and the important role that the defense plays in maintaining a law-abiding society where we can feel that only people that a jury has found to be guilty beyond a reasonable doubt are put in prison, and that an innocent person does not accidentally either go to prison or become executed. As I became more and more ideological, I saw myself as an adversary against the government and against the potential of a police state. And so I thought it's critical that that the most hated people in our society receive a defense, because the tools available to the police and the kind of behavior that I saw at the local level with state police was a mixture of very good work and respect for civil rights, and a large number of individuals who didn't feel that way at all. And then in terms of federal work, a system that is designed to grind people down and put them in such fear that they will plead guilty, even if they think they're innocent. So I see myself and my colleagues as a vital part of keeping our country a democratic institution.
Nice.
And if that means that some people I represent are bad people, it's simply the price that we pay for keeping everyone else safe.
What people don't understand is most of the people, almost all the people, they're not bad people. I can count on one hand in my 26 years of practice how many people that I thought, and I still don't even like to say the word bad people, like they're fundamentally broken and they've done horribly bad things. But man, most of my clients, first of all, the crimes aren't all that serious. The violent crimes are a small sliver, but they're just like you and me. And they, they're but for the grace of God go I, so when people ask me about those people, I say they're not those people. There are people. They're you. You just
Right.
haven't been there yet. And by the way, you've probably committed a few felonies in your lifetime. I'm pretty sure. You just never
Yeah.
got caught. So maybe next time you're alone in a quiet room, ask yourself why that is.
Yeah.
Because nobody's looking, no one's shining a light on you, right? My philosophy was shaped by a professor in undergrad. His name was Professor Harold Popinski, and he was my criminal justice. And I took a class called Alternative Methods of Social Control, and it blew my mind. He had us reading Howard Zinn and all this stuff. They just never taught you that in high school in Carmel,
Yeah.
Indiana. But he had this thing called the lightning rod effect, which is power gravitates towards modes of least resistance. And that put everything into very clear perspective for me. So anyway, so I should tell folks, so yes, you started at the public defender, another great myth that we labor under, which is public pretenders, and that people go to the public defender's office because they can't get hired at a real firm, and they're no good. That this is nothing could be further from the truth, people. I would not be the lawyer I am today if I hadn't done the first 4.5 years, 5 years of my practice as a public defender. I received the best training. I received the best hands-on experience. Unlike my friends at the law firm who were carrying the briefcase of the partners for the first couple of years, I had a building full of veterans who I could ask for advice at any time of the day or night. And I had brothers and sisters in arms that I could always commiserate with. And it made me the lawyer that I am today. So, but anyway, you've had a trajectory, and I'll kind of flash forward to now because you have your own firm. It's the Jon May Team Defense. And your firm, it's down there in Florida, designed to bring together the finest team of lawyers, forensic investigators, and experts to confront the government in major federal prosecutions. Jon May teamdefense.net for anybody who wants to check it out and learn more. So you're doing amazing work federally, and you've had some pretty interesting high-profile clients over the years. We might talk about that, but right now I just want to dig in. I want to circle back to the book, Who Says You Can't, and talk about let's just talk about this idea of sentencing and trying your case at sentencing. In your book, you frame this really well, because I was in my head, I like to talk to trial lawyers and say, stop calling yourself a trial lawyer. You don't go to trial. You go to trial in 3% of your cases, okay? And of those 3, 1.5, 2% are going to end up at sentencing. So 99% of your cases are sentencing cases. You're a sentencing lawyer, so stop saying you're a trial lawyer. You get in the mindset that you are a sentencing lawyer, but you actually do this better than I do it, because you say you are a trial sentencing lawyer. That's how you refer to it in the book, which is to say sentencing is a trial. Sentencing is litigation. There are issues in dispute and ways that you can challenge your case and tell your story, that the only real difference are there's no jury and there are no rules of evidence. But other than that, it's a trial. Tell me about that.
Well, first of all, I, like you, want lawyers to begin with a different mindset in approaching their cases, recognizing that 98% in federal court, 98% of the defendants plead guilty, and of the other 2%, 70% who go to trial are convicted, which means that the odds are every client that comes into your office is going to face a judge for sentencing eventually.
Yeah.
Okay. And knowing that, I believe it's important to begin looking at your case, not just in terms of how you might pitch it in terms of plea bargaining or how you might present it in terms of a trial, but using all of the techniques of investigation and the use of experts that and motions that you would do in preparing to go to war at trial, looking at all of those tools from the first day you meet with a client in how they can serve the interests of getting your client both the best plea possible and the lowest sentence is a mindset that lawyers should adopt in how they go about practicing law, because this has very significant implications for things that they need to do differently. So
give me some examples of the implications and things that lawyers could be doing differently in that context.
Okay. Well, lawyers are often constricted in terms of what they can do, or restricted in terms of what they can do by the federal rules of evidence. So when lawyers think of how they're going to review discovery and conduct their investigation for presentation at trial, they put it within a scheme that forces them to see how a particular piece of evidence would be admissible, or what challenge they must prepare for if they're going to seek to introduce a particular piece of evidence. But there are no such limitations at sentencing, other than some restrictions as far as attorney-client privilege, or basically attorney-client privilege issues. Anything is admissible at sentencing. Hearsay is admissible at sentencing. And the court is required under the sentencing guidelines to consider, or under 3553A, to consider anything that the defense wants to present. Now, a lot of lawyers feel intimidated by this because they're worried that the government is going to introduce something like hearsay, for instance, at the sentencing proceeding, which they're not going to be able to challenge. They can't challenge evidence that was suppressed. I mean, everything that usually puts them in control, and trial lawyers want to remain in control, is freewheeling at sentencing. And this is a great tool and a great power for defense counsel when they start thinking in terms of defense, what they can do and not what the prosecutors could do. For instance, during the investigative stage, if you're lucky enough to know ahead of time that the government is looking into the activities of your client, and certainly post indictment, you have a window of opportunity to speak to potential witnesses that are going to disappear by the time of trial, because they're going to be intimidated by, if not directly by prosecutors, by agents. So people who you might normally want as witnesses at trial are not going to be available to you. But you have a window of opportunity to meet with them and either get a formal statement from them under oath or have your investigator interview them. And whatever favorable testimony that they could offer, which you can't present at trial without having them at trial, you can nevertheless present at sentencing. Okay.
Yeah.
Because whether you've got an affidavit or you've got the testimony of your investigator, okay, it's perfectly admissible.
Yeah.
At sentencing.
I love that, because I think that a lot of lawyers go to law school because we relish the rules, we relish the structure. We understand that, and we can live within those walls of those constrictions. But then you get to sentencing, it's no holds barred, it's wild, wild west, anything goes, and people kind of get freaked out. But look at it for real, like the whole sentencing process is premised on hearsay. I mean, the first shot across the bow is going to be the pre-sentence report. That's just layers and layers of hearsay. The government's given all the police reports, the 302s, to the probation officer, and those police reports have statements in them from people. It's just, and then the probation officer sums it up in the report. And these sentencing letters, everything we do is hearsay. So the fact that lawyers are shy away from that is always interesting to me. The other thing, and you said it already, but it bears repeating, is my colleague and mentor of mine, Alan Ellis, says, I said, when do you start preparing for sentencing? His answer is when the check clears. This idea that, and like you said, by the time a lot of lawyers, they want to cross the threshold of, okay, we've pled guilty and now we have that sentencing date, so now I'm going to start getting ready for sentencing. But as you point out, at that point, it might be too late for some of this stuff. Some of these witnesses who have said, yeah, I'm out. Right. So early sentencing. Here's another thing that I have experienced in my journey, because I work with lawyers all over the country, and many lawyers are of the mindset that, well, I pled guilty, so I have to just fall on my sword, admit the crime, and don't challenge any of these aspects of sentencing, because that's just going to make you look like you're not sorry, you're not accepting responsibility. It's going to make the government mad. It's going to make the judge mad. It's just going to make things worse for you. I literally had a lawyer say to me, when I suggested that it was a sale of narcotic drugs resulting in death, and the client gave a consent search of his apartment, and they found a very large amount of drugs that appeared on its face too large for personal use. Now, he did sell the drugs to one person, his best friend, who unfortunately died from this. But it wasn't a sale per se. It was two addicts and a best friend saying, please, 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 can you get me these drugs? But the government's narrative is he's a drug dealer. And if you look at this amount of drugs we found in the apartment, obviously he's a drug dealer. And I said to the lawyer, first of all, it's not true that affluent people with massive substance abuse problems, it's not unusual to have a large amount of drugs. Second of all, there's no other indication he's selling drugs, no ledgers, no scales, no text messages, no money, none of that stuff. Right. You can't let this narrative go untouched. The judge has to understand he's not a traditional drug dealer. Right. This case is different. And he looked at me and he said, Doug, if I'm talking about the crime, I'm losing every time. And my head almost exploded off of my shoulders. Now, thankfully, eventually we came around, we told the story, good things happened, but this is not, and I'm not trying to diss on the lawyer, because I think it's a common mindset. I'm afraid to talk about the crime. I just want to talk about, oh, they gave money to the Humane Society, and they're a really good dad, and their family's really going to miss them if they go to jail, and we're just going to do that dance and leave this portion untouched. But it strikes me about you, and one of the reasons why I love you is because you're putting the allegations on trial at sentencing. So where's the disconnect? Or I guess my better question is, what would be your advice to the lawyer who says to you, Mr. May, if I'm talking about the crime, I'm losing every time?
Well, the crime's there. The prosecutor's talking about the crime. I mean, he's making the situation as bad as it can be. If you have an argument to be made, it means that there are circumstances that can put the crime in a different light. Judges, particularly in pleas, know nothing about the client. What they read in the PSI is the government's view of the client, and it gives them no understanding of the person, which of course is one aspect of what we do as far as humanizing the client. But they often have a very wrong impression of the nature of your client's culpability. Going back to what we were talking about a minute ago, as far as what you could do with the witnesses who are no longer available. I'm not talking about. You could have, let's say, a white collar case. You could have a series of emails that may not be admissible as business records, but may very well, let's say they're from colleagues of your client, they may very well explain what was really going on in a transaction, and your client's responses to them, which would also be inadmissible, may well show that while at some level he understood or he knew that what they were doing was wrong, nevertheless, it wasn't for the intent that the prosecutor says it was, where the prosecutor has turned this into something truly evil. And while it's true, a crime was committed, your client has admitted to participating in the crime, but that's why we have in state cases the difference between manslaughter, second-degree murder, and first-degree murder, because we recognize that a homicide, where your client has killed an individual, okay, and the method of the killing is the same, and all the facts and circumstances are the same, but in some instances, it's excusable, it's justifiable, it's manslaughter, it's second-degree murder, it's murder. All the same act. And yet what the client intended, what the circumstances were that led to the commission of this act, makes the crime makes the crime an entirely different animal, which justifies greater or lesser punishment. And so unless we are willing to challenged the government's interpretation of what happened criminally. We are leaving it open to judges to determine the client's, what's going to happen to the client for the rest of his life, where often judges, like many on the U.S. Supreme Court, have had no experience as trial lawyers, no experience either as prosecutors or defense attorneys, whose entire life has either has revolved around their academic experience in law school and their experience in a white shoe firm dealing with other affluent, upper middle class individuals, and so they have no experience to really judge another human being, and so it's up to defense counsel to the extent possible make them see what the real picture is, not the picture that the government has. And I really think that, whether or not you're talking about how much money a defendant obtained from a fraud, or how it came that he ended up in possession of a firearm, even though he was a convicted felon. These are all circumstances and today, where judges have the authority to vary down from the guidelines
and do so regularly. You can plead guilty to a crime, okay, and consistent with your plea, simply explain the circumstances. And like I said, I have been in sentencings that have gone on for days. All right, judges don't like sentencings that go on for more than a couple of hours. I don't care what judges think about that, because at the end of the day, if I'm able to convince the judge to give me enough leeway to be able to present my case, and if it takes, I can do it in 3 hours, or if I have to take like 3 days, even though the judge might be annoyed initially with me, in the end of the day, he or she will understand more about the client, and I have to hope that they take out any of their frustrations with me, but not with the client. And in